Be ready and start. Respondents 1 and 5 have in their statement contended that the writ petition is not maintainable and that no public interest is involved in the matter. Stop. It is alleged by them therein that the writ petition has been filed with political interest and ulterior motives by the petitioner, who is admittedly the state president of a political party. Stop. It is also averred therein that Exhibit P2 final report clearly reveals that the state policy has completed the investigation and has filed the final report before the jurisdictional magistrate, who has taken cognizance of the matter. Stop. Respondents 1 and 5 thus seek dismissal of the writ petition on the ground that a public interest litigation is not maintainable in a criminal matter and that the petitioner is only a stranger who is in no way connected with the alleged crime. Stop. We have heard Shri Manu Rama, learned advocate appearing for the petitioner, Shri Jay Shankar versus Nair, learned advocate appearing on behalf of respondents 2 and 3, Shri T.C. Krishna, learned advocate appearing on behalf of respondents 1 and 5 of the Learned Standing Council, appearing on behalf of the fourth respondent. Stop. We have also heard the learned government pleader appearing on behalf of respondents 6 to 9. Stop. Since the question of locus standi of the petitioner to prefer the writ petition has been challenged by all the respondents, and the same being is question that goes to the very root of the matter, we deem it fit to consider the same at the outset. Stop. The learned counsel for the petitioner has invited our attention to the judgment of the Supreme Court in Dr. P. Nala Thampi versus Union of India and others, and he contends that in defining the rule of locus standi of public interest litigations, no rigid litmus test can be applied, and thus the dominant object of public interest litigation is no ensure observance of the provisions of the Constitution or the law, which can be best achieved to advance the cause of community or disadvantaged groups and individuals. Stop. Basing on the said dictum, learned counsel for the petitioner further submits that public interest litigation necessitates appreciation of doctrine of locus standi on a case-to-case basis. Stop. Since the respondents are with oblique motives and under undue political pressure, delaying further necessary action in the criminal proceedings arising out of the FIR in crime number 146 of 2021 of Kodakara Police Station, which according to the petitioner have serious economic consequences for the nation. The objection of locus standi raised by the respondents is devoid of merits and unsustainable. Stop and over.
अगर आपको कोई भी वर्ड डिफ़िकल्ट लगे, उसकी आउटलाइन के लिए या किसी भी तरह की कन्फ्यूज़न के लिए आप नीचे कमेंट करें। थैंक यू।